started. Okay, it is 8:30 p.m. and today is very unusual for me to do this lecture, an introduction to criminal law on a Wednesday. But you know what happened yesterday is that there were some problems with WebEx at about the time that we were going to have our lecture, so I notified everybody. So this is the final lecture, and I hope everybody is staying safe out there. Um, Here in Illinois, it's pretty rough. I just saw something that I had never seen. There's a town called Oak Park, Illinois. It's just to the west of Chicago, and those people have been ordered to stay in their homes by the mayor of their town, and it's really very, very, very serious. There are all kinds of things going on with this coronavirus situation, and restaurants are closed here, and except for being able to carry out and order carry out, it's it's really really something. People are working from home. I've already been working from home, so but even our campuses, they're closing down many of the campuses, and Rasmussen, even the personnel who work in the school, yeah, are ordered to stay home. Yeah, so it's it's pretty bad, and people shouldn't take this lightly. And I even read something that was very interesting, that there is in the works for the President of the United States to have the government to issue money to families, adults. They were talking about as much as 1,000 per person, and disaster relief. And I don't know how that's going to work. There's mortgage companies that are working on moratoriums, foreclosures. I just saw a 60-day moratorium. But yeah, the city of Oak Park, if some of you may be familiar with it, has declared a state of emergency and to shelter in place. And that means that those people are not to go out except for essential services, to stay at home in their houses. It reminds me of something that I read about martial law. It's almost like the same thing, but it's this is um, this is something. I just tell people is stock up. We went to the grocery store the other day, and people were taking stuff off of the shelves so fast that it was unbelievable. Bread. I saw water disappearing. Our family likes to drink Ice Mountain, and we couldn't find it many places. So, yep. And then we went to the Walmart where we get Ice Mountain water, and it was empty. So I went online to try to find some. There were places that you could order it for 24 bottles, $40. Unbelievable. But anyway, whew, so I guess my other job as a pastor keeps me pretty busy. So yeah, it's pretty crazy what's going on here. So anyway, let's get right into the module, because the course officially ends on Friday at 11:59 p.m. Central Standard Time, and you'll see Lecture 6, I'll be giving you a key phrase. So let's go and take a look at the announcement. So the week 6 announcement, defenses to criminal liability. And chapter 10 of the textbook, which I have sent you PowerPoints already. And then dealing with the activities, mental disorder, insanity defense, we're going to talk about that. Involuntary intoxication, mistake of fact and law, and a little self-defense. And then we're going to conclude dealing with the key terms for practice, mistake of law, mistake of fact, and the practice quiz, the final practice quiz that we have here. And you're going to see that your written assignment for the week is going to be the final exam, basically what I refer to it, and we'll talk about that a little more in detail. The discussion assignment, murder or self-defense, many of you have done pretty well with dealing with that. From yesterday, the initial post was due, and then, of course, Friday, the final reply post is due. And then the quiz, as I said, a time quiz, which you're familiar with because you had this one in week 3. And you know how many questions there are because it's the same setup as week 3, except the content of the material, which will be due this Friday, is going to be covering the materials from weeks 4, 5, and then this week 6. And then here's your bold reminder that the course ends Friday at 11:59 p.m. And then there's a end of quarter survey evaluation. If you could complete that, you can complete that after the 20th if you want. It'll still be in there, but we appreciate you completing it. It lets us know about what you think about the course. And then you know what my motto, adversity is the springboard to success, is all about. And then let's take our final look at the course calendar, and you'll see that this is it. This is where we are. Day after tomorrow, the course ends. Day after tomorrow. And so the reply post you see is due, the written assignment, which is the quiz, and then it tells you again, it reminds you that the quarter ends. And then the key phrase, there's a quiz. And then there's a quiz there. Let's see, I think it's up here. Yeah, the live classroom final phrase. And the course is over, absolutely. All assignments are due to be in by that time. Okay? Now, if you don't have some arrangements with, not me, because I can't extend it beyond the 20th unless there's something that you have to do. We didn't talk about it during in the first week of the class, but it's indicated in the module. It's indicated within the lecture for week 1, and it's included in the syllabus actually. That's the only way, and then it has to be completed and set up by me before 11:59 p.m. Central Standard. Otherwise, it doesn't work. So let's take a look at week 6 assignments. There's your discussion modules, and then your quiz, a time quiz set for 30 minutes. And I told you the best way to practice for that is to look at your PowerPoints for the week. Also, at the same time, take a look at the practice materials each week. Pay close attention to those practice tests that I have been giving you a few of them at the end of each class, as I will again tonight, because they will help you, especially the quiz, then your live classroom lecture. Very important. So there's no more use of the rubric for grading for week 6. It's strictly the exam, and then your rubric for your discussion post is the same. Now let's go over the topic for tonight. Self-defense, mistake of law, excuse defenses to criminal liability, and then we're going to deal with insanity. So we're going to deal with this, mental disorder first, involuntary intoxication, mistake of fact and law, self-defense, and then our key terms. Okay. Remember, you got these items here, the assignments. So we're going to deal with these 3 things here at the end. So let's talk about what exactly is the issue of, let me move this out of the way. Okay. What exactly is the insanity defense? And people tend to think that the insanity defense is a defense that somebody does something and they're, quote, out of their mind. But there are certain standards, and we're going to talk about the three standards that are generally used throughout the United States, or really I should say actually 2, but only one state uses one of them, and you'll see what we're talking about in a few minutes. But the insanity defense is what we call an affirmative defense. And when we say an affirmative defense, it means very simply that you admit that you performed or did the act, but that you have legal reasons why you should not be found guilty, or shouldn't be charged as a criminal, or shouldn't be found guilty as a criminal. And so insanity is so difficult to prove that I can tell you that in my entire career as practicing, from when I graduated in '78 to when I retired in 2000, and even before that when I worked with lawyers and studied, and while I was in law school and following cases, and since then, I never was able to apply the insanity defense successful, because it's very, 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 very particular. I do know of some cases, and I'm going to talk about a situation that I'm familiar with that involved the affirmative defense. So affirmative defenses, also called justification defenses or excuse defenses. So what they do is they excuse the crime, they justify the act that you did. So with the insanity defense, we generally talk about the individual having a lack of capacity to be able to appreciate the criminality of their acts. And it is, as it says here, for defendants to be convicted of most crimes, the prosecution proves beyond a reasonable doubt and deals with the mind, or mens rea. And we talked about earlier about premeditation or intending. And so they commit an act and it becomes a crime. But the defense, as it says oftentimes unsuccessfully, as I've already said, is that the defendant lacks what we call mental capacity to commit a crime. So what they're saying is that despite the fact that they committed the crime, they didn't have the requisite ability or knowledge or intent to commit the crime. And so it is very, very rarely a successful defense. As I read it here, it says the most widely recognized affirmative defense is insanity. While many have heard of the defense of insanity, most do not realize the consequences. Because first of all, what you're going to discover as we talk about this is that when an individual is found not guilty by reason of insanity, they're not going to be able to leave and just go home. They're going to be committed to a mental hospital and treatment until they are able to be tried. And so when someone is found not guilty, they don't walk out of the courtroom. They find themselves in a hospital. So basically, they're still going to be incarcerated. It's interesting because of the fact that people are incarcerated, or rather not incarcerated, but they're put into a hospital for guiltiness of a crime when they're found insane. I said that people who commit crimes and they're on drugs, that they should be placed into hospitals and treated, and that would help deal with the issue. So kind of using that as a parallel. So when that individual there is released back into society, then they go through all the steps to have recovered. The same thing as I've advocated for drug treatment. So a judge allows this to happen by a court order. Now, there's some states that don't even have the insanity defense, such as Idaho, Kansas, Montana, and Utah. Now, what these states do, as it says here, is they kind of have a form of it, but they don't call it that. They allow for an individual to be considered to be guilty, but mentally ill. And the person in these states is said not to be guilty because of the mental disease or defect. Well, it's not any different, really, from what you're going to discover that it takes for a person to be found not guilty by reason of insanity. So there are three types of defenses that are considered insanity defenses within the United States. The Norton Rule, we're going to talk about that first, and then we're going to talk about the Durham Rule, and then the substantial capacity test found in the Model Penal Code, which many states follow. Now, the Durham Rule is only followed in one state, and we're going to talk about that in just a minute. But let's talk about Norton. The Norton, that's how it's pronounced. It's M. Norton, but it's Norton Rule. And it came from England, as much of our law did. And the person is found not guilty by reason of insanity, if, remember, at the time of the offense, the mind was so diseased, sick, that it didn't allow the person to recognize the act of what they were doing. In other words, they were blinded to what they were really doing, and also called the right-wrong test. So basically, they couldn't determine right from wrong. And when you reach that stage, the court would determine that you were not of a mental state when you committed the offense. And in the statute, in some states, such as the example they give here in our module, says that the defendant had a mental infirmity, disease, or defect, and the condition prevented the person to know what they were doing, or either to recognize the consequences of what they were doing. Or the alternative, it says the defendant knew what they were doing and its consequences, but the defendant didn't know what they were doing was wrong. That's why it's called the right-wrong test. So it's kind of interesting. And so many jurisdictions were using that for quite some time. And that was the original insanity defense that many people studied when we were in law school. That's pretty much the one we studied in law school. But then there came about through legislation in some jurisdiction. One jurisdiction is called the Durham Rule. Now, this came out of a court case, Durham versus United States, in 1954, and New Hampshire was the only state known to use this, and it is known as the product of mental illness test. Now, you got to be very careful listening to these because they sound so similar. But look at what it says, and I'm just going to have to read it to you. It says, according to the Durham Rule, and this came out of the case that became part of the law in New Hampshire, is that the product of mental disease or defect that excuse the criminal liability. So the sickness said that it prevented the individual from recognizing what they were really doing. That's pretty much what it is. So in the case of Durham versus U.S., the right-wrong test was criticized, which is interesting because the media is so close, because they said that the right-wrong rule was too simple. In other words, they said that the mental illness was more complex than simply looking at right or wrong. I think that they're looking at it from the perspective that the Norton rule would almost put you in a capacity like a child. I mean, a little child. I mean, a baby child, an infant child, or either a very little toddler doing something. And that's the thing that they were saying. So they said that, no, it's not just right or wrong, that some actions could be the product of mental illness. So the Durham test made it even easier to find insanity and stretched the intellectual question of only this. This was a question that the defense had to prove. Did the person at the time they committed the offense know the difference between right or wrong that is expressed in Norton? So, and so the Durham test is more liberal than Norton, but it stretches the intellectual question of did the person know what is right or wrong. So that the point that it was easier to reach a determination of insanity. While you might say that Norton was more conservative in terms of reaching that stage, but then Durham came along and stretched it out and basically said that that Norton was too simple, but that in reality, the Durham test, as it says here, is more liberal than the Norton and stretch the intellectual question. So it's kind of opened up the door for more people to be able to find themselves insane. Again, it's only in New Hampshire, so you don't really have to just be aware of that. Now, the substantial capacity test is the test that many jurisdictions use, including our jurisdiction here in Illinois. And it came about through legislation, and it took away the recognition of Norton. The defendant didn't know the difference between right and wrong, but placed instead the result of a mental disease or defect that lacked substantial capacity. So the mental disease left the person with the substantial capacity to appreciate the wrongfulness of their conduct to conform to the requirements of the law. So Wisconsin statute is an example of it. It says a person is not responsible for criminal conduct if at the time of such conduct as a result of mental disease or defect, the person lacks substantial capacity to appreciate the wrongfulness of their conduct or whatever they did. Now, they focus more on an illness or sickness that individuals have. Because of that, it's important, as it says here, to remember that the defendant is presumed sane. So, excuse me, just like you're presumed innocent until proven guilty, but it's presumed that all people are sane. But it's the defendant who then has to present the evidence, as I said, in an affirmative defense, that at the time that they were insane when the event took place. And it says, depending upon the state, the burden of proof to be successful in the insanity defense is either preponderance of the evidence or clear and convincing. It's not beyond a reasonable doubt, but it's more like a civil case. So what happens? It says that, of course, as I said already, that what happens is a person is sent to a hospital or something. Now, there's what we call a bifurcated hearing. And so what happens is that there's a hearing to determine that if the defendant wishes to pursue a not guilty of reason insanity, the separate hearing is held to determine if that is true at the time of the crime. And so the defendant really generally, in both sides, psychologists, psychiatrists, who will provide proof or attempt to persuade the trier of fact that the individual was basically, as we use the term, out of their mind at the time the offense was committed. And in many jurisdictions, the judge, and in some cases, the jury will make a decision as to whether or not the defendant is insane or competent. And so if they're insane, of course, I already told you what happens. You're ordered to a mental facility until you're no longer mentally ill or dangerous. And that's how people sometimes spend the rest of their lives. John Hinckley, as some of you may or may not know that name. Do anybody know the name John Hinckley? Anybody know that name, John Hinckley? You can type in the chat box. I'll see it. Yep. Yeah. Yes. And what happened is that he attempted to kill President Reagan, but yep. And it really didn't. Reagan didn't really get shot, and the bullet didn't hit him, but it hit his. I think his chief of staff, Brady. And he was, and he's passed away as Reagan, but Brady was the one who resulted. You got it already. Is that the chief of staff, and then he ended up becoming the poster child for what became the Brady Bill, and that had to do with dealing with firearms and weapons and things of that nature. So the point of the matter is that what I'm getting ready to tell you is that do you know where Hinckley is now? Anybody know? Nope. He was. He's out. This was yes, he was. He was there for many, many years until I think it was last year. Let me, if I can get the goods here for you. But I think up until last year, he was finally released. Give me a minute. Here we go. Yeah. Okay, now it says that John Hinckley, this was as of September of last year, was tried unsuccessfully, and then he was put into a mental institution. But following a status before a district court judge, Hinckley's attorney told CNN, this was in the news, that there was no timeline. But anyway, the point of the matter is that it was 40 years, and then since he was released from the hospital in 2016, he was there committed by a judge and was there that long. At this time now, I think he's actually, he was living with his mom when he was first released in 2016, and now he lives independently. But that's the exception. Most of the people spend the rest of their lives in those kinds of facilities. The experience that I had with seeing someone in that condition was a young lady by the name of Amanda Wallace. And Amanda Wallace was a young lady who had, and this goes back to when I was still practicing. And Amanda Wallace had her child taken away from her by the Department of Protective Services in Illinois, called DCFS, Department of Children and Family Services. And she got the child back somehow. We don't know how, and they don't know, people generally don't know why. But within a short period of time after she got the child back, she hung the child. And it was ridiculous. And I had a chance to see her. She wasn't my client, but I had a chance to see her because I was at the facility visiting a client of mine who was awaiting trial. And this young lady was sitting in the corner, balled up, rocking side to side, and that's how she spent most of her time. So we said, and she was one of the few people who've been found guilty in Illinois of insanity. And so we all, as lawyers, came about and said that from that point that we knew that in order to have a person to be found not guilty by reason of insanity, then you had to apply what we call the Amanda Wallace rule. That was some term that we lawyers came up with. But what it amounted to, if you saw this lady, she wasn't faking it. She was just, in her own mind, she thought that she was hanging an animal or something, which may be animal cruelty, but what she really was doing was hanging her own child. And that's the extent of it. But it's a very, very, very difficult thing to prove. So that's the circumstances. So now you understand now how pretty much the disease mind things operate, but the different tests are so close. But just remember that the Durham rule, they don't really test you too much on that in these tests, but they do test you generally on the Norton rule, and sometimes a substantial capacity. But the Norton rule was the common law determination of insanity. So let's now move on. Let me see, I want to go back to the chat. Somebody said something, I want to cover it. It says, yeah, okay, good. Here's a suggestion of where you can read about Amanda Wallace. Let me see if I can click it and bring it up. Okay. I don't know. Let's see. Is it in here? Amanda. Oh, it's under probably W. So they probably have it under the last name. Okay, let's see if we can come up with it. Leslie Ann. Oh, here it is. Amanda Lynn. Yeah. April 19th, 1993. So let's pull that up. Thanks for bringing that to my attention. Yep, that's her. Boy, I remember that young lady. And so look, she was classified as a murder. 20, 20 years of psychotic behavior, and one victim, and that was the child. And it was in 1993. She was arrested the same day. She was very young at the time, 2-year-old son with an extension cord around the neck. And then she said goodbye and hanged him from a transom, it says. This happened right here in Chicago. Sentenced to life in prison without parole in 1996, but she committed suicide in 1997. So strangled herself. So, and so here's some more of the story, and you talk about when she finally took her life. So thank you. I never knew about that site. I will keep that in mind whenever I teach this class again. I appreciate you giving us that murderpedia.org. I appreciate that. Thank you. Thank you. So the insanity defense is something that is, very rarely done. But that is a classic case right there in our state, in our jurisdiction. So intoxication, voluntary intoxication. You know what voluntary intoxication is? Going and getting drunk on purpose, or going in a situation where you knew you could possibly get drunk, taking a drink or drinking. So, but it is only an affirmative defense if the person is intoxicated, was done so involuntarily. You cannot do what we call voluntary intoxication. So this is about saying that you were intoxicated, but you didn't know that you were going to be intoxicated. And but you cannot drink and become intoxicated and then claim it. That's why I say it in the normal course. So if you look at the basis for, let's use the Michigan one. This is the one I like to use. Under the influence of alcohol or drug defense is prohibited exceptions. It is an affirmative defense. Remember, I told you that earlier. All these we're talking about affirmative defenses that's raised by the defense to a specific intent crime, so that the defendant then, by preponderance of evidence, must prove that that he or she voluntarily consumed a legally obtained and properly used medication or other substance, but did not know or reasonably should not have known that they would become intoxicated. So the point of the matter is if you drink alcohol, do you stand the chance of being voluntarily intoxicated? Yes or no? Do you? If you drink it voluntarily, do you stand a chance of being intoxicated? Yeah, because it's the choice to do the drinking. There are people that say, "Oh no, I can drink, but I'm not going to be intoxicated." Well, I beg to differ with you. And if you look at what we talked about when we talked about DUI a few weeks ago, it means that what the statute says is 0.08. Well, in all surrounding circumstances, an individual is considered intoxicated when they're not in control of their faculties based upon some intervention where they got high on drugs. And I'm not talking about a situation where you double dosed your medication and didn't realize it. That's an involuntary intoxication defense. And that's pretty much where you're going to find yourself. Or if somebody slipped a Mickey in your drink or something like that. That's pretty much the only way that you're going to be able to apply the involuntary intoxication. So, and the key thing is that it takes away your mind. And it says here, example is that the person didn't know the difference between right and wrong as before, but the fact that it was done involuntarily negates the responsibility, such as someone slipping something in your drink, as you can see from these facts. And that's pretty much where you're going to find it, or an accidental double dose of your medication. Let's say you took medication. I take, for example, a medication once a day for my blood pressure, but if I accidentally didn't realize, oh, I took it in the middle of the day, and then that would be involuntary intoxication, okay? And not drinking Red Bull, not something high that's in caffeine or those kind of things. But people take those drugs, you know, to stay alert and things like that. So, so it says here that if the classmate lied about the pill and was actually a prescription for something else, and it had adverse effects causing a person to go into a panic or rage or do something out of control, they didn't know. They didn't know. They thought they were taking an aspirin or something like that. Then, in that case, then it would be considered as involuntary intoxication, because their actions came about without them voluntarily doing it. So I guess I could just, in summation, say about this section, if you take a drink or do something on purpose, then in that situation, then you find yourself in a situation where you cannot be found not guilty. You are going to be guilty of intoxication and found guilty, and then you're going to end up serving some time. So guys, just remember that point as you go through and deal with the issues that you run across when you're tested on this. So it's pretty much something that happened that was beyond your control, okay? So now let's move on to a mistake of fact and mistake of law. Very simple concepts. First, the first one. Mistake of fact happens when someone accidentally does something, or they do it in out of ignorance of being told. Okay, let me give you an example. If a person does something that they believe is legal, and a normal person would believe it's legal, then in that case, it might be a mistake of fact. Under Missouri law, like mistake of fact, the defense can be claimed if the action related to an element of the law comes into question. Let's use this example. This is the best way to get you to understand. So let's use the scenario that they give us here. This person makes a large purchase of goods, and she's paying in the store, and then after she pays for her items, she distracted by her phone, or either doesn't pay attention to the clerk and doesn't notice that the clerk didn't scan another item, one of the items, and she leaves out, and then the loss prevention officer stops to arrest her for not paying for the item. Well, the police are called, and then saying that she should be charged with theft because she didn't pay for it. But then the young lady could argue mistake of fact because she didn't have the intent not to pay. She wasn't trying to get over on the store, but it was negligence on the part of the clerk in not doing so, and she wasn't paying attention to it. I can tell you something like this happened to me. It wasn't of that capacity. I was in Walmart, and I usually, when I go to Walmart, I get one of those little riding cart things, and I ride it through the store because the floor is rough on my back. So I will ride. And so I remember I bought some of these little drinks that are fruit drinks. And so, the lady rang the fruit drinks up, and then I said, "Oh my God!" My wife was with me. I said, "I forgot my wallet." So I said, "Let me go get it." So I get outside to my car, and I get my wallet, and then I get in, and I notice, and I look down, and I says, "Oh, there's one of the drinks in my cart," and the lady hadn't rung it up. Now, I had, if the police or somebody had come out saying that I was trying to take it without it, then I could say, "Oh, I'm sorry, I didn't even notice it." But on the other hand, let me say this, and I tell people honestly that outside, when I discovered it, and I was outside the store and nobody else was around, I decided, what the heck, I'm not going to pay for this, and put it in. Legally, I'm in violation of the law, but then I have other issues too, because I'm a Christian and I believe in other things that will get me in trouble with my boss, who is God. As you know, I'm a pastor. But my point being is this, is that if I was stopped by the loss prevention officer, and I would necessarily probably not be able to be found guilty of theft of that one little container, but it would be a mistake of fact and error. I'm sure that all of you have been in situations. There are people who says, "Oh, good, I got it. I didn't have to pay for it," and you get to the front. That's why they have these people that are supposed to be checking at the front of these stores, like Sam's Club is doing, and like Walmart is doing, and many other places. The point of the matter is that you get to a point that sometimes there's a mistake. I know we had a whole case of water. I'm talking about in normal times now. I'm not talking about in recent times, where we had a case of water under the bottom. And then I always would tell the lady, "There's water on the bottom. Make sure you scan it. Make sure you scan it." And then the other day we were in the store, and something we bought, and my wife says, did you ring that out to the clerk? And she says, "Oh, I'm sorry, not the water." But the point of the matter is very simply, it's not the mind is not formulating taking it without paying for it. That's the key. All right. Now, mistake of law is another example that we talk about here. All right. And so with mistake of law, it's a defense when an individual finds themselves violating the law, but they believe that their actions were legal. And so mistake of the law is not the same, though, as ignorance of the law, because we already know that ignorance of the law is no excuse. And look at how mistake of law can be applied. For example, if a person relied upon a law that was later found to be unconstitutional, you can't charge that person with it. A person acted in good faith, consistent with a judicial opinion, or it was misapplied, or the advice of an agency or person responsible for administering the law misinformed that individual, or the person committed an act contrary to law that was not yet published. And so let's look at this example with Paul. This is really a good one about Paul riding the ATV. So Paul had his license suspended, and he wanted to drive his ATV to work. So they contacted the local sheriff, and the local sheriff's department said that Paul could operate his ATV even though his license was suspended. So that's who she got the advice from. All right. Now, Paul was advised that he could operate it as long as he followed the other laws. But one day, he was stopped for speeding with his ATV and was cited for operating with, not the speeding part, but for operating with a suspended license. And he was convicted for driving with a suspended license, it says here. And the court and jury didn't permit mistake of law as a defense. And so on appeal, the court said these words, or indicated that the trial court made a mistake and should have allowed mistake of law to be used as a defense. And so Paul had only drove his ATV because of the advice that was given by a law enforcement person or deputy. Now, could that argument end up being the same thing if someone's lawyer told them that? Do you think that that might be able to be applied in terms of mistake of law if the lawyer was wrong about it? What do you think? Okay. Anybody else? Carol says yes. Anybody else? The answer is sometimes yes and sometimes no. It'll depend on a case-by-case basis. I believe that a good lawyer, and I know I was a good lawyer, could present a case strong enough to help the individual who would be able to take that defense and probably get a trial court to be able to say, hey, that person relied upon someone who is an expert or advised them. So if you notice, it says that a person acted in good faith with a judicial opinion, a person acted on the advice given by a person or agency responsible with administering the law. Okay, is a lawyer responsible for administering the law? The average lawyer? No, a judge is. But the lawyer is not. But the point of the matter is that so it's an argument, but I think you'd be stretching it. What you'd probably end up doing is suing your lawyer, and you'd end up being found guilty of the offense. So it would be a yes or no. But anyway, just remember the examples that they usually consider you to be aware of are the ones that are given here, and we'll have a few of those in our practice as we move forward. If you have any questions or comments anytime about any of these, hit me up because we're moving pretty fast. We got a few more to go. Self-defense. Self-defense is probably one of the most well-known affirmative defenses that's utilized in court. My very first case that I ever represented a person in that was serious was a double murder case, and I pled the person not guilty. But what happened is that two guys were coming to stick up the crap game, and when the guy that led the crap game, who was my client, let them in, they got in and they announced that they were there to stick up the place. Well, my guy shot those individuals when they had their guns. And then he walked up the stairs and shot them in the back several times. So, do you think there's a chance that this person could be found not guilty by self-defense? Do you believe that there is a way that that person could be found guilty or not guilty of murder or double murder? I'm reaching for something. Okay, there we go. Got it. Do you think that? Do you think that? Can you tell me a way? Why do you say he committed the act of murder? Because he did what? Because he shot the two guys. Did they have guns? I said they had guns. If I didn't, they did have guns. But he shot them in the back. So is he guilty of murder? Was he guilty of murder? Yes or no? Okay. Because I'm going to tell you something. It says, okay, yes, there are a lot of people on there. Okay. Okay. Oh, wait a minute. Let's go on. No, because he committed the act of murder. He shot the two guys and killed them. Yes, they had guns. Wait a second. It was a self-defense if they were there to harm him. And he was protecting himself from harming other, or was he just protecting himself? But he shot him in the back. So what does that tell you? Does that mean then that he is still, is he guilty of murder? Okay. Let me tell you what happened. The young man fired shots with them facing him. He was down the stairs, leaning upward, and they were on another level, but they were on a level that was about 5 or 6 steps above. And he fired 2 shots at each guy, and each guy hit the ground when he fired the shots. They dropped their guns and hit the ground. Then he ran up the stairs and emptied his gun in their back. And that was the problem with self-defense to most people. But there was something that I kept saying, we're going to find something. Here's what happened, good people, is that I was able to do it took me a year to come up with everything I needed. But I found the medical examiner's report, finally got it. And the medical examiner's report said that the 2 individuals who died were killed as a result. And I asked these questions, were shots fired with them facing him, and that when they hit the ground, both of these guys, they were dead because the shots that were fired by my client were in self-defense because they had guns and they came to stick up the game. But the shots that he fired in their backs were no effect. Do anybody know why? Any of you know why? Okay, here's the answer. When he shot them with the 1 shot each, they hit the ground, they died instantly from the consistent angle of the shot. When he went up to the top of the stairs and emptied his guns in their back, they were already dead. So you can only kill a person 1 time. And so the medical examiner's report supported my position that he was consistently operating in self-defense when he shot those individuals because they were there to rob the place and they had weapons. And he was found not guilty by the jury. But and I've had other self-defense cases, but this was this is my first one, and everybody was so, oh man. After that, everybody wanted me to be their lawyer. I became very popular, and I successfully represented a lot of people. And self-defense was one of my big defenses. But let's just talk about self-defense in general. Is that it has to be a burden that the defense raises. Just I did. I said, yes, I admitted to the jury. Yes, my client shot and killed these people, but I'm going to prove beyond a reasonable doubt or preponderance of the evidence that when you examine all the evidence, you're going to discover that the reason he did it was to protect the others and or himself. And that's what I raised as a defense. And that's what successfully is proved in any self-defense case. So the amount of force that's used must be consistent with the force that was involved here. So let's say, for example, let's take the scenario with my client with the gun, pulls out his gun, and these two guys don't have a weapon. By the way, there was never a debate about whether they had a weapon. But let's say if they never had a weapon, and then they announced that they were there to do something, but they didn't brandish a weapon, and you didn't see a weapon on them. It is probably likely that it would be murder in that case, exactly. Reason being is because you didn't have to have a weapon because there was no weapon seen. Now, if they had a knife and he had a gun and he shot them, would it still be self-defense, yes or no? What do you think? He had a gun, they had a knife, or they each had a knife, or one of them had a knife. The key is this. If the knife is a dangerous weapon, then in that case, yeah, it's self-defense. If it has to be, quote, a dangerous weapon in the vicinity of people. Okay? So let's talk about justifiable homicide in an action. Some of you may or may not know about this case, but there was a young man that was shot 16 times by the name of Laquan McDonald. Some of you were in another class of mine and may have seen 16 shots that I talked about. And anyway, this was a Chicago police officer who shot this young man 16 times. And he originally had argued that the individual was a threat or a danger to him. Well, the video that came out established the opposite, and the knife that he had was so little, and he was walking in another direction, just brandishing it. He wasn't swinging at anybody. And the police officer got out and shot him 16 times. Consequently, it was excessive use of force, and it wasn't justified under Illinois statute. And he was the police officer, in a rare occasion, was found guilty of involuntary manslaughter or second-degree murder. But the point of the matter is, it could have been, and not sentenced to long periods of time. But the key thing was it wasn't, quote, justifiable what the person did. So anyway, he ended up going to jail. So the key thing is that you can't use force that is beyond that which is necessary. Let's use this example of Bob walking on the sidewalk with Margaret, and they're approached by a drunk man who threatens to punch Bob. Bob attempts to avoid the conflict and tells the man, just keep walking. So the man shoves Bob, draws his fist back. Bob reacts quicker and punches him in the face, and the person hits the ground. And Bob was upset because he was still upset after that. And he jumps on top of the man and beats him until he becomes unconscious. And Margaret pulls Bob off of the man, and they wait for police. So What about Bob? Was Bob guilty of self-defense? It says in here. Was Bob guilty of self-defense? Or did Bob use self-defense, should I say? Well, the truth of the matter is that Bob was up until the point that he jumped upon the man's back and started beating him with his fist. No, because he originally used self-defense, but he went beyond it. Notice what it says. It says, and he threatened to punch Bob in the face. Bob attempts to avoid and tells the man to keep walking, but the man shoves Bob and draws him and hits him. So Bob hits him. So at that case, it's self-defense. But then Bob upset. He was upset over the assault. He jumped on top of the man and beat him. Then in that case, he went beyond his defense of self-defense. Everybody get that point? Yeah. The force that was used to beat the man while he was on the ground and made him unconscious took him out of his self-defense. So look at what Illinois. So Bob had gone too far. That's the point. That's the point. So look at what Illinois statute says. A person is justified in use of force against another when they reasonably believe that the conduct is necessary to protect themselves or to protect another against serious injury or possible death. That's it. Or commission of a felony. So in most states, individuals can use self-defense. Now, and the duty to retreat exists in some jurisdictions, but all of you are familiar with the stand your ground because of the Trayvon Martin case. But stand your ground, all it simply means is that you committed an act in a place where you're supposed to be and that you were protecting yourself. And so I think, to be honest with you, those people who really looked at the facts determined in an improper way applied to stand your ground with the person, George Lopez. I think his name was George Lopez. Not George Lopez. I can't think of his name, but you know who I'm talking about, who was convicted of a lesser included offense. But anyway, the point of the matter is to stand your ground is that the duty to retreat, which was involved where people had to do it. And I always thought the duty to retreat was ridiculous because you can hurt yourself in terms of that. And that you don't have to, you can defend yourself as long as you were in a place that you're supposed to be rightfully. The battered women syndrome, jumping right into that, is when a woman who has been beaten for many years reaches the stage, or a man now in the cases that exist, where they've been the victim of a domestic violence, or George Zimmerman, thank you. But with the battered women syndrome, in this case, a person has been abused many, many times. And so it developed a state of mind that said that they needed to protect themselves, and their mind was controlled by any circumstances that appeared to put them in harm's way where they could be the victim of further domestic violence. And it's been used as an affirmative defense to justify murdering an abuser. Now, and it's a mental condition caused by the domestic violence or cycle of violence, and is used with self-defense laws. Now, here's a scenario that I'm familiar with, and it's a friend of mine that I knew for years. We went to high school together. She was married to a violent guy. He used to beat her all the time, and regularly. Well, one day he came home and he would beat her, and then he would go to sleep. And then she would get a weapon and she would shoot him while he's asleep. The battered woman syndrome was not used, and she was found guilty of murder. And the reason why is because it was believed that she had a chance to escape and get away, and that she didn't have to do it at that time. She had other means. However, a pretty good lawyer, which I saw the case, I saw some mistakes that the lawyer made with the jury, and I believe that the jury could have found her not guilty using the battered women syndrome. But look at this scenario here. It says Diane had been physically abused and battered many times by her husband over the past 10 years. Each time it occurred, he's drunk, and he battered her and knocked her and choked her unconscious. But one night, Jim comes home drunk, and they begin to argue over his drinking problem. Jim escalates, and Diane, fearfully that she'll be substantially battered again, shoots Jim. In this case, Diane is likely to argue self-defense in conjunction with the battered women syndrome. And she probably would be successful because she did it in the act of that taking place. Now, if my friend, for example, while he was beating her and ran and got a gun and shot him, her husband, I'm talking about now the scenario I'm talking about, then she probably could have applied it. You remember when I talked about the difference between manslaughter and murder and how it applies? That's the same way that this applies in terms of the battered women syndrome. Again, you can see that the battered women syndrome is an illness that sets in, and what many lawyers have argued is that, and successfully, is that that person's state of mind was changed. But when that person waited the person to go to sleep, and then they went and got a weapon, then that meant that they planned, and then they shot and killed that person. But in this case, where it's done simultaneously, then in that case, then it's not murder, because and that's it. So you got it? Everybody got that? I saw the comments. Yes. Okay. So now let's move on, because we're over our time, but I got to make sure that you get this information. The castle doctrine, I'm going to go over this pretty fast. It's basically meaning that a person should be safe in their home, and that you can use the force necessary to protect the individuals and protect your home. It came from the old history that a person's home is their castle, and now the castle doctrine has been extended to businesses as well. So what it did, it said in the castle doctrine, you don't have to retreat because you're in your own home, and an individual comes in, and then you can use deadly force on that individual. That's pretty much what it says. And then finally, use of force by police officers. Police officers, as I said earlier, I kind of talked about this early, have to use the force commensurate with all the surrounding circumstances, and going beyond that could result in deadly force, where a person could be found guilty even as a law enforcement officer for violating the law. Okay? So I'm not going to go over this in detail. So any questions about any of these methods of force? Okay. So now let's get into these key terms. So let's see how how well you do with this, because these are things that will help you prepare for your exam that's coming up in a couple of days. The types of affirmative defense, including mental disorder, involuntary intoxication, mistake of fact, and mistake of law, which excuse the unlawful action. What do we call these? The types of affirmative defense. Excuse. It's just simply called an excuse defense. Justifiable, right, but it's an excuse defense. In other words, it gives you an excuse for why you did it. All right? A defense that can be claimed if the person violated a law but believed that his or her actions were indeed legal. What do we call that? Very good. A test only used in New Hampshire that is applied to determine if a person was sane at the time of the offense. What's it called? Okay. It's a Durham rule. Applied to the intoxication defense, the level of proof necessary to successfully prove an intoxication defense, a preponderance is often referred to as 51% certainty, merely more than half. Preponderance of the evidence. It told you in the question. Sometimes you'll have the answer right there. Okay, let's flip the card over again. See it right there? See it? It's right there in front of your face. It was too easy. The type of affirmative defense, including use of force, self-defense, defense of others, and deadly force. What do we call that? Is also in front of your face. Justification defense. See it right there? When you're taking the test, remember those kind of things. Your question obviously gives you an answer. Sometimes. Defendants may admit that they committed a crime, but the law provides an exception for which they should not be guilty despite their admission. What is that? Affirmative defenses. Remember, that's all we've been talking about. Everybody got that? You see, so what happens is that they admit they committed the crime, but the law says an exception. But the person should be not guilty despite their admission. It's an affirmative defense. You see that now? Does everybody see that now? That's pretty much what most of the lecture was about. Do you see it? Okay. All right. Just make sure you see it on the test. All right. Let's go. And then we'll do one more. When someone commits a crime but misunderstood the fact that negated the element of the crime. Yep, because you saw it right there. See, now you begin to see. It could be right there in front of you. You know, you could say, wait a minute, that's nope. They're giving you a biscuit or bone. And then the last one I'm going to do is used as a defense. A person can only successfully claim intoxication as a defense to criminal liability if the intoxicated or impaired state was involuntarily caused. What do we call that? One of the earlier things we talked about is right here. Say it again. I saw it. The answer is this: intoxication. Used as a defense, a person can only successfully claim intoxication as a defense to criminal liability if the intoxicated or impaired state was involuntarily caused. What is the state? Intoxication. But it has to be involuntarily caused. All right, so those are some of the things there. All right, let's get to the next group here. Mistake of law or mistake of fact. All of these are involving this. These are good. Some of these are actually on the test. Okay. Jane has a white cat named Snowball that wears a pink collar and let outside each day. One day the cat don't return. A few days later, while looking for her cat, she finds Snowball and brings her home. However, later that day, she realized that the pink collar has a tag with the name Princess on it. She contacts the police, but fears she will be arrested for theft. So what is that? Mistake of law or mistake of fact? Yep. This is mistake of fact because she thought it was hers. Okay. Now, after she determined that it wasn't hers and then she decides to keep it, then she might get into the next phase. Eric waves down a police officer and asks, "My landlord locked me out of my apartment. Can I break in to get my stuff?" The officer says, "Go ahead." Eric breaks in, and the landlord demands the person be arrested for burglary. So, yep, because an authorized person told him. So, yep. So, it's a mistake of law because the officer considered an official carrying out the law, and that's it. So you got that. Do one more. Officer White is working a theft case and believes he has the right to enter without a warrant the suspect's apartment to retrieve the stolen items. Just to be sure, Officer White speaks with the on-call judge and explains the case to him. The judge advises Officer White to enter the apartment and retrieve the items, which he does. It's later determined that the Officer White violated defendant's Fourth Amendment rights. What is that? Absolutely. Because the judge was the one who gave him that, and he relied upon that. Okay, so now you begin to get the gist of how those work. So now I'm going to conclude with, no, we're going a little longer, but I think you'll find it valuable for you. Okay, this is the big thing. This is, you already took one, so you know what they look like. Okay, you're defending a case where the defendant, Derek, is accused of killing his friend, during a schizophrenic episode and believed he had to kill his friend because he was the devil. You don't believe that Derek knew the difference between right and wrong. Okay, what test should be? Everybody should get this one. Yeah, because it gives you the answer actually in the test. Exactly. You see what I'm talking about? Pay close attention to the question. David is hanging out with friends at a local bar. Somebody places an unknown liquid in his drink, which causes him to go crazy, strip off his clothes. The next day, David has no recollection. What affirmative defense? Was he insane at the time of the offense? No, it was intoxication. It was involuntary intoxication. Yep. Then the last one I'm going to do is this. What level of proof must be met in order to be successfully prove an intoxication defense? Somebody's been paying attention. Exactly. 51%. So, so you guys got it. Excuse me. Any questions about this? Anybody have any questions? Rolling down. Any questions? Okay. Well, I'm going to give you the key phrase. Anybody want to take a guess at what I think I might give you as the key phrase? Any guesses? No, that's not the phrase. Not sure is not the phrase. I'm messing with you. Self-defense. Okay. That's close. One more guess. Nope, you gotten farther away. The word defense is in it, though. What is it? There we go. All right. Affirmative defense. Affirmative defense, people. Give me that, and you get your points for this week. Well, again, guys, it's been a pleasure. I appreciate you guys consistently coming out each week. And I saw, Gress, that you were there last night. But I didn't think you were going to be there last night because you sent me an email asking me if the class was going to take place because of the confusion. And you still showed up. That's okay. I kind of laughed about it because it tells me in my phone who showed up. I think Adam was the other person that showed up. But I think that you guys quickly, I guess when you saw the email, so, but Grass, you should have said, hey, wait a minute, I think Professor Wright's not doing this because, no, but anyway, it was fine. I appreciate it. So anyway, thank you guys. Thank you, Carol. I appreciate that coming from any of my students. I have students that don't agree with me on some things, and they sometimes get upset with me about sometimes the way that I grade them, but I explain to them, I'm not trying to hurt you. I'm trying to help you. I'd rather you get a poor grade than get out there and not perform well professionally and get fired from that job. Because you can overcome that grade, but when you mess up on that job, it kind of like might blackball you in the area. So you guys kind of feel that way. My goal, as I said from the beginning, is to provide that each of you become professional, educated, and ethical criminal justice professionals. And thank you again, all of you. Again, yes, adversity is the springboard of success. Thank you. Appreciate that. Always remember that whenever you get into a tight situation. So, again, if any of you need any referrals from me, try to reach out to me. I apologize that lately people have been reaching out to me for them, and I haven't been able to get back to them very fast because I had a lot of things happen when we moved in November the 8th. Things just went crazy and trying to get things. And believe me, it's just now, what is this, the 18th of March, and we're still unpacking stuff. You know that. If anybody ever moved, you know sometimes it takes a long time to unpack you. So, well, thank you guys again, and I'll say good night to you. And your final grades will be all posted no later than Monday night. 11:59 p.m. Central Standard. That's a rule that I have to do. So I'll be grading weeks 5 and week 6. Um, so so, yeah, I know you know. I know you told me that too during the course of of the quarter, and I'm very sympathetic. So I try not to take away points from people who do those in that situation. Very, very, very important. I try to be fair, I try to be firm, and I try to be consistent with every one of my students. So, all right, guys, good night to you. I got to end this so I can convert this, and I'll see you in a future class. Thank you so much. I appreciate that comment. Thank you. All right. Good night, everybody.